Do you understand the ranking system used to determine a trademark's strength? Well, you should. Stay tuned. Hi, I'm Tricia Dunlap, Managing Partner of Dunlap Law, a small business law firm in Virginia, here today to talk with you about trademarks. This is the third video in a series. Almost anything can be eligible for registration as a trademark. A word, phrase, image, color, or sound can earn registration if you are using it in commerce, or you plan to, and it's distinctive. Let's tease out that second criteria. What does distinctive mean in the world of trademarks? Anything that distinguishes your good or service from your competitors is a trademark, but not all trademarks are eligible for registration with the U.S. Patent and Trademark Office. There are 5 categories of marks. Think of it like a pyramid. At the top of the pyramid, the strongest marks are called fanciful. These marks are invented words that have no inherent meaning on their own. And when they're first coined to identify a good or a service, they're literally invented. Examples include Zillow for real estate, or Rolex for watches, Xerox for copiers. In the early years of the commercial use of marks that are fanciful, the owner of the marks has to invest a lot of money in marketing and advertising in order to create an association in the consumer's mind between the mark and the good or service. The next level down in the pyramid are marks deemed arbitrary. These marks are existing words that have a known meaning, but that meaning is not associated with a good or a service that's being sold. Examples include Apple for computers or Lotus for software. The third category of marks are suggestive. They require a leap of imagination to link the good or the service to the mark. Examples include Microsoft for software, Netflix for video streaming, or Airbus for airplanes. The fourth category of mark is descriptive. Examples of a descriptive mark include maybe Crystal Clear for water or American Airlines for an airline. Generally, descriptive marks are not eligible for registration unless the applicant can show that over time, consumers have come to associate the mark with the good or the service provided under the mark. Surnames such as Hyatt also fall into this category. Hyatt Hotels has a registered mark because the name Hyatt acquired distinctiveness over time, thanks to years of advertising. The fifth and weakest category of mark is generic. Examples include maybe tissue for toilet paper or clock for clocks. Generic marks are never eligible for registration. Here's an interesting tidbit. Sometimes a fanciful mark can become generic because they are so successful in linking the mark with the good or service in the mind of a consumer that consumers begin to use the mark as a generic term. Think about the word aspirin. That was originally a fanciful trademark. The fanciful mark Google is also at risk of becoming generic as people increasingly use it to describe the act of searching online. Dunlap Law's attorneys can help you work through the names you're considering for your good or service so that you can strategically choose a strong mark. The higher your mark ranks on the pyramid, the more distinctive it is and the stronger and more valuable it is. Registering with the USPTO creates a business asset. When you sell your business, having a registered mark allows you to command a higher price. Dunlap Law can help you figure all of this out. We're more than lawyers. We take a holistic view of your business's challenges and we advise you accordingly. Only you can protect your business. Let us help you. Follow us on social media and sign up for our newsletter to learn more. If this video has been helpful, I hope you'll like, subscribe, and share. Leave me a comment down below and maybe I'll use it in a future video. I'm Tricia Dunlap with Dunlap Law, a small business law firm in Virginia. Thanks.